Hey there, it's Michelle Caruana from Play Cafe Academy and Profitable Play. And if you are a current or prospective indoor playground owner right now, I'm sure you have joined one of the various online ownership groups for indoor playground and play cafe owners, whether it's my group coaching program, Playmaker Society, or any of the free groups that are available. And if you haven't joined any of those groups, I highly recommend it. It is such a crucial step in your business planning process, especially if you are looking to go into business with somebody else or anything like that. I hope you are in those groups doing all the research, asking all of the questions, learning from the other owners in the industry, because really in any industry, some of the most important insight that you can glean is from other owners in the industry, the good, the bad, and the ugly, right? So if you are in some of those groups, I'm assuming that you are, some of the trending topics that you may have seen lately over the past year have been around terms like copyright, trademark, cease and desist, lawsuits, litigation, things like that. And unfortunately, there is a lot of fear and confusion being created in this industry. And something that has really come to my attention in the last couple months that has quite frankly really disturbed me is that a lot of indoor playground owners are dealing with these sorts of legal issues in the dark. And they're feeling really alone. They're, like I said, feeling very confused. And that's something that I never want for anyone in this industry, whether you are part of one of my programs or not. And I've created this audience, and I feel a very strong sense of responsibility and obligation to protect those people that listen to my content that are thinking of entering this industry. I never allow you to look at this industry with rose colored glasses. And one of the things that may come up in your ownership journey, whether it's before you open or a year after you open, are these sorts of legal issues around copyright and trademark. And I want to have an open and honest conversation about it. I never feel like anyone should be dealing with these sorts of issues alone. You should always have somebody in your corner. And I really feel like it is my duty as a content creator, as one of the many content creators in this industry, to protect the integrity of this industry as a whole, help keep empowering people to better their communities, make a living in this industry legally and safely. And again, I wanted to have an open and honest conversation so that hopefully even one less person watching this feels alone and dealing with these issues. Now, I, however, am not a lawyer. This is not my area of expertise. So I wanted to bring on an expert to have this open and honest conversation with you. I am welcoming my lawyer to the podcast today. Now, if you've been watching my content a while, you are familiar with MJ, and I will allow her to introduce herself in just a moment. But she is somebody that I trust. She is somebody that has helped me with copyright, trademark protection, brand identity in the past. Again, I cannot recommend her enough. If this is something that you have been dealing with and you're feeling alone or you want somebody in your corner, I am going to link MJ's website in the show notes of this podcast or in the video description, depending on whether you are watching this content or listening to this content. So today we are going to talk about things like what research you should be doing before you launch your business to make sure you are operating legally and within your right, what sorts of things can be trademarked and protected, and what sorts of things cannot. We are going to talk about what to do if you receive a cease and desist from another owner in this industry, what steps to take, whether or not you should panic, and what that process might look like. We peel back the curtain and make it a whole lot less scary. And then finally, we talk about what you should do if you feel like you may be being targeted with meritless claims, or if you feel, again, like you are dealing with these problems alone. We're going to talk about what you should do and what steps you should take. So without further ado, let's talk to my lawyer, MJ.
All right. Hi, everyone. My name is MJ Morley. I am the owner and founder of MJ Morley Law PC. We are a obviously we are a woman-owned boutique law firm, but we are a team of mothers, and we work primarily with online businesses as well as local boutiques and shops in Buffalo, New York. We love what we do, and I'm really excited to be talking to Michelle today.
All right. And thank you so much. You have helped me so much in my own business. So I really trust the information that you provide. So to get started, and this is something that you really helped me with, before someone launches a business, what precautions do you recommend they take, or what research do you recommend they do to protect themselves legally?
Yeah, we have kind of a few things that we recommend doing. The first one is sometimes people think, when they form their LLC or they form that entity protection, they immediately need the perfect name. They don't, right? You can use anything you want. You could form an LLC that is just MJ and Michelle in Buffalo LLC, right? And then when you figure out the name that you want to operate under, that's when we really want to do the research. And that's not just Googling your name. We would like you to do a full kind of comprehensive search. We offer a search that is, searches through all of the state databases, the USPTO, state trademark databases, business names, social media names, domain names. It's very thorough, just to figure out if there are any conflicts. And there are a lot of tools that do this. We pay for a software that is very expensive, but it allows us to feel good about the results that it gets. I think sometimes when people say or hear that you need to do a trademark search, they go to the USPTO website and they plug in the name that they're looking for. And if they don't see it, they think the name is good to go. And that is a misconception. It's kind of not how that works, but even doing that is better than doing nothing. Um, but I would definitely reach out to attorneys. Law firms most offer this as a flat rate where they will use their software, do a very comprehensive search, and then offer you their opinion on whether or not you'll be able to use and protect that name. Too many people kind of skip this step, and then you end up with like a cease and desist letter 6 months later, when you've already put up a sign, printed business cards, kind of built that website. So if you want to avoid a potential fight later, we definitely suggest that you do your homework up front. Um, and don't think that just because the name is available, right, as a website domain or a social media handle, that it means you're in the clear. Those systems are not checking everywhere they need to check for trademark conflicts. So that comprehensive search is definitely something you should be doing as soon as you've settled on the name that you want to operate under.
Because I'm sure it may seem like a cost up front, but redoing everything and rebranding and going through the process after, I feel like would be much more expensive.
It honestly it is, and just having that kind of peace of mind, knowing that you're moving forward on solid ground, I think that's totally worth it. And then I think people sometimes assume that talking to a lawyer is going to cost a lot of money. Most law firms that are operating in this online space are offering this as a flat rate. It's affordable. A lot offer payment plans. I think it's just completely worth the peace of mind to do that search. It does not mean you need to file for a trademark right away. It just means you want to make sure that you can use that name.
Yes. And you brought something up that I want to dive deeper on. So, the saying that the best time to do all of this was yesterday, the second best time is today. So, what if someone listening opened 6 months ago? They unfortunately skipped this step, they didn't do their research, and now they're doing a trademark search and there's a conflict, or they're receiving a cease and desist from another business owner. What does that mean if they receive a cease and desist? And we'll start there and then we can kind of talk about next steps.
Yeah, I'd say a cease and desist, it's actually very common that either if a client receives a cease and desist or if we send a cease and desist on behalf of a client, that the recipient thinks that they are being sued immediately, right? And that's not what's happening. A cease and desist is a demand letter. It's basically someone saying, we think that you're infringing or you're doing something unlawful, stop it. It is not a lawsuit. It is not a court order. Do we write them as attorneys? Yes. But I know that some clients handle them themselves and they'll send them out as soon as they see something that they think is infringing. It does not by itself carry any legal weight, right? So you can't take that cease and desist and say, I gave you a cease and desist. Now stop, like cease. That's not what happens with that, right? There's no judge involved. It's kind of a warning. It's very different than the filing of a lawsuit where someone actually went to court, filed a complaint, and started litigation against you. So we kind of say, think of a cease and desist as like a knock on the door. Someone's trying to open a conversation with you about whether or not you are infringing on their brand. And I would also say that if you do receive one, really look at what they are saying and don't panic right away. I would hate for someone to receive a cease and desist and then immediately think they have to do everything that that letter says they have to do, because that is not normally the case.
And some cease and desists I feel are very valid. Like you can use me as an example when somebody literally right click downloaded my logo, put it on their door without making any changes whatsoever. I felt good about sending that because it was a direct copy of my logo and I would have been fully prepared to take the next steps had they not ceased using it. However, I know some people, like you said, will just send cease and desist as soon as they even feel somebody is infringing on their brand. Can you talk about when to take action as somebody who receives these letters? Or, maybe realize that the content of the letter is not something that they need to take action on. Can you talk a little bit about, what a real cease and desist is and one where they might not have standing?
Yeah, I would say, honestly, I know that lawyers get a bad rap, but if you receive a cease and desist, kind of my first thing I would say is do not panic, right? Getting a letter does not mean that you're in the wrong. Read that letter. It will typically have things like trademark and copyright and brand protection, and these are our assets and that kind of language. It doesn't automatically mean you're in the wrong, especially if in developing your brand, right, you didn't look at anyone else's. You have a record of how you developed your logo or your name or the content on your website, or you worked with a designer in your boutique or in your play space. Like, getting a letter does not mean that you did something wrong. So, first tip is do not panic. The second tip, I would say do not ignore it. Sometimes when you ignore a cease and desist letter, and I'm not sure if we dealt with that, just not getting a response. If the person who sent the letter feels like they have a strong position, they're going to send a second one, right? And a third and a fourth if they need to. So ignoring can escalate things quickly if the other side has a strong position. I would also say call a lawyer. We used to operate in a time, I think, where lawyers were, like our dad's lawyers and our grandfather's lawyers, and they were scary and it felt like a whole thing. Now, most of my peers, I know we offer complimentary consultations. We will jump on a Zoom call with you and kind of talk through what everything means, have someone evaluate whether those claims have any merit, whether, sometimes they are legitimate and sometimes people are bluffing and just posturing. Um, and I think it's really important to figure that out right away, right? Do they have any case here, or is this like puffing up our chest and bluffing?
And is that common? You see people sending cease and desist letters knowing that they can't file anything legally or wouldn't have a standing?
We're seeing it more and more. And I think it's because we're all operating, we used to be kind of in our own towns, our own states, our own villages, and now we're all operating online. So we see what other people are doing. And if someone is doing something that seems close to us, it's not that hard to send out a cease and desist, right? For some of our clients, we have the letter ready to go because it happens to them over and over. Um, that could be the case, right? That someone thinks you've stepped too close, and they're going to send that cease and desist to ask you to stop. It's unfortunate, but yeah, it's a little bit scary how often we're seeing letters where we're like, what are you talking about? Just because we operate in the same industry, or because, I'm teaching someone how to braid hair on the internet and you're teaching someone how to braid hair on the internet. We're not copying you. You don't have a protection over this whole industry. And that's really frustrating as a lawyer, because you're like, why does this client even have to come to me and pay me to write a response when it's clear you do not have, they do not have the rights they say they have.
And two things that I kind of want to talk more about. But first, just to walk people through the process, because again, I've gone through this process and it did seem very intimidating. So let's just walk through the steps. So somebody gets a cease and desist letter, they don't panic. They, call you, they call another lawyer, and you decide that the cease and desist letter does not have merit. They do not have copyright or trademark claim over what they do. What's the next step? You said a response.
Yeah, so and that's the other thing about it is if you reach out to us, we're going to evaluate the claims, right? We're going to look at what they say in their letter. We're going to look at your website content, what they're alleging you've copied or stolen or you're infringing upon, and then we're going to respond. And sometimes that means negotiating with them. Sometimes that means rebranding if they're right, and sometimes that means pushing back, right? And telling them, no, kick rocks in legal terms, right? And you want to go to court over this, we'll see you in court. Realistically, what that means is I'm going to take their letter and call the lawyer that wrote the letter first and say, I do not agree with anything in this letter. What's the goal here? What's happening? If we have a lot of the times, the lawyers then can have a friendly, respectable conversation and we move on. If we need to send a letter back, we will pushing back on their points. And sometimes there'll be some back and forth with letters. Um, Sometimes after that initial phone call, they go away, right? We don't hear from them again. That has happened a lot this year where we call the lawyer, we say, you don't have any, this does not have any merit. We're not doing this. Maybe we have to send one letter and then we never hear from them again. Um, the worst thing I think that you can do, and we do see this sometimes with social media, is that someone will send you a message on Instagram saying like you're infringing on my brand or this, you're copying me, I have a trademark. And then we have these kind of like very emotional DMs back and forth between people. To me, it's like if you get an Instagram or social media DM, I'm not as worried. If you get a actual letter, then reach out to an attorney. But the worst move really is to kind of engage and have those emotional messages back and forth, because that could be used against you later. So I would not just respond, especially when you're heated in that kind of moment.
I absolutely wanted to just send a DM when somebody sent me that photo of my custom logo on a door,
Yeah.
but I didn't. I am so glad. So I took a deep breath. I messaged you immediately, and it was so nice that we already had a working relationship, and I was able
Yeah.
to, we were able to take care of it pretty much right away. So I'm so thankful that I did that. So I can definitely attest to taking a breather, taking a step back, and just reaching out for professional help. It made it so much easier to navigate. But going back to something else you just said, you talked about having merit versus not having merit. Can you just mention a couple things, a couple examples maybe of things that a business would have trademark protection over versus something that they would not be able to have protection over?
Yeah, so a trademark covers kind of what we call brand identifiers, right? So names, logos, slogans, and sometimes, like in your case, even colors, right? Sounds, product packaging, like Tiffany blue, right, is a protected color with that logo. So you can't trademark generic terms. Like I can't trademark law firm or coffee shop or um, what we call kind of a descriptive phrase without showing that they have gained distinctiveness. So if your brand is kind of core to your business, if you're investing in marketing, then you should file a trademark. But remember that you can't protect like the concept of a braiding. I don't know why I keep saying braiding, probably because I've never done a fight over this. I can't protect the concept of a salon that just does braids. I can protect the brand name and the logo if I want to, the slogan, but not that business exists, right? Not the concept of the business.
And let's say that a business owner, hypothetically, they decide that, again, let's go back to the hair braiding example. Let's say a business decides that beyond their logo, beyond the colors and things like that, they decide that they want to intimidate other hair braiding businesses from existing in the space. And they do start sending out cease and desists for things that they do not have protection over, like the business concept, for example. Can you talk a little bit about what that might look like and what someone might do in that scenario?
Yeah, I'd say that's one of those things where if we get a letter like that, my phone call to that attorney, I might not even call that attorney. I might write a very scathing letter back about how this is absolutely ridiculous and baseless and harmless, right? So if you're getting a letter just getting a threatening kind of cease and desist probably isn't enough for you to go after them. But if they escalated that and you resulted in, you ended up in court, I mean, you'd argue that that is completely bad faith. If they're speaking about you publicly online, saying, they're copying me or they did this or that, that's where you could say you could have a defamation claim if you can show that what they're doing to you is hurting your reputation. Uh, you can pursue them for that. But not every bad letter, is malicious and that we're going to have to go after them. But we are going to respond very aggressively to that, right? And tell our clients, I'm not going to swear on your podcast, but like this is the
It's
BS
okay.
word, because that is just if someone is kind of weaponizing these letters to bully their competitors, I mean, that's a problem.
And as a lawyer, let's say hypothetically, you get a client who has received one of these letters and you come to find out that there are dozens and dozens of other similar letters that have been sent with similar meritless claims. What would that signal to you as a lawyer?
It would make me very angry. And now I'm like, what is going on here? But no, you'd respond to that letter very aggressively, ask for proof. If someone's claiming like intellectual property rights, tell me what those rights are. Tell me what you have. You'd respond very aggressively to that. The reality is that, they probably don't have the protection they're saying that they have. And I would tell my client, that if they know of anyone else dealing with a letter like that, to tell them that it's probably classic overreach, right?
And again, hypothetically, if somebody does get, again, one of these letters, they know there are other people out there who have gotten similar letters and they share just a copy of the letter somewhere without, specific context, just, asking for help, asking if anyone else has received it. Is that allowed? Are you allowed to do that?
Yeah, I'd say you're saying like just share it in a group or share it in a community or send it to a friend, that kind of thing.
Yeah, I guess, are you allowed to ask for help? Like, let's say you're one step before hiring a lawyer. This is the first time you've gotten something like this. And you want to know if anyone else is experiencing it and what your next step should be. Again, maybe you don't listen to this podcast.
Yeah.
Are you allowed to do that, or is that, potentially defamation?
I mean, the biggest defense to defamation is truth, right? So if you receive a letter and you post it on the internet and say, I don't know what to do about this letter, that's not defamation, right? If someone is sending letters like that, they're sending them to an outside source. They're not keeping them confidential. There's no reason that you shouldn't be able to share it, and ask for help or support. If there's a group for online braiding and you say, is anyone else getting this letter? There's no issue with you doing that. In my legal would my legal advice be to post it? Probably not. It might inflame the sender. It could look bad if you did actually end up in litigation, but no, I don't see how you're getting in trouble for posting, especially if there's no added context.
So let's say that, again, somebody is listening to this podcast and they're just launching their business, or maybe, again, they are the second scenario where they're a couple months in and now they're receiving a letter, or they're worried about their intellectual property, or they're wanting to trademark. Where can we learn more about you and potentially reach out to you?
Yeah, our website is just MJ Morley Law. Um, you can book a free 10-minute consult. If you have a letter like this, like if we're in that consult, we will be discussing the letter directly, and figuring out how to respond. We are primarily a flat rate business. So before, you hire us, you'll see what the price would be to send out that letter response, evaluate, and kind of negotiate with the attorney. My biggest thing would just be like, if you do get a cease and desist, like breathe. This is not a lawsuit. You are not a bad person. This happens every day. Call a lawyer. Like that is why we do what we do, and respond strategically. Like don't fight in the DMs is our big thing. If
Yes.
if someone's sending bogus letters, right, they're the ones kind of walking that legal line, not you if we're receiving it.
And having someone in your corner that is a professional at this, I can't say enough good words about you guys. And if anybody is, again, feeling overwhelmed, or if anyone is feeling, attacked or bullied by a letter that they feel is meritless, please reach out to MJ and her team. Again, try not to engage directly. I can't tell you how comforting it is as a business owner to have somebody that is a professional who does this all the time, and is so passionate about helping small business owners, especially women, especially moms, protect themselves and their livelihood. So I'm so happy to have you on the podcast again.
Thank you so much, Michelle. It's been a pleasure. And yes, please, anyone reach out that wants to talk cease and desist. We are definitely here for you.
All right, that wraps up today's conversation. Again, if anything we talked about today resonates, I've linked all of MJ's information in the video description and in the podcast show notes, depending on whether you are watching or listening. But I hope you have a great day. Bye for now.